good information for the public to know. It's not really advertising.
Yeah, but what happened then for us then is that we call people up and they say, and what happens then is that the managers cannot even correct us if we have an inaccurate story. So we'd be calling people up and we'd be like hearing, this is an exaggeration, but oh, we hear your fund is down 10%, and they'd be like, we can't comment, we can't. So it really has tied managers' hands quite a lot. And it's interesting because you've seen the mutual fund lobby and mutual fund PR efforts, banks, and basically every other corner of the financial industry that has massive PR behind it, and I think as a result has got much more favorable press than they would have otherwise. And when you see hedge funds, they're more often than not are demonized in the press, especially in the quote mainstream press, outside financial trade publications. So for us, this is a big change just from that point alone. And without any advertising. And from what I've heard from managers, a lot of them, and some of the other panelists have touched on this, a lot of them are very hesitant to have aggressive advertising campaigns or any advertising campaigns because they're not sure how it will sit with the existing LPs. And then they're not sure if it's going to be effective. Because bottom line is, I think that hedge funds still aren't interested in attracting a retail audience for the most part. So putting an ad on the side of a bus or in a magazine or a newspaper or something, it probably would question the effectiveness of it. Maybe for again, smaller targeted things might make more sense. But again, for us, the big picture is that the whole PR thing and the fact that hedge funds can now do PR and that they can now speak to the press is where it's going to be, we're going to see the most ramifications.
Yeah, that's really a good point. The SEC has really had a hard time getting their heads around the great proliferation of information. Probably all of you can Google yourselves and find out all kinds of information about yourselves, your companies, even the performance of your funds that are private. And so how do you manage that whole process? This is interesting. We get into this discussion. I've done, since April when the law was passed, I've done about 25 of these kinds of panels. And it's really interesting to hear people talk about, well, we would never do that at our firm, or we'd only do it just this way. And I think, well, now wait a minute. Remember back in 1994 or 5 when we had this thing called the internet, and everybody said, web page? I'm never going to have a web page. That would be ridiculous. Why would my company need a web page? Well, now everybody has a web page, and with respect to this provision, my view of it is that it'll take one company to do it correctly and be successful, and that will be the model. And then everybody will say, yeah, whether I want to or not, I really kind of have to do this. Steve, are there ways to break this down so you do certain types of things? So, for example, branding is one thing, but what about advertising performance? Doesn't that raise separate issues?
Yeah, and what we're talking to our clients about right now is until the rule is settled, you can't even really think about performance advertising. The other day I was with a $25 billion credit fund, and they said to me, we will never advertise. They said, however, we realize that once the Jobs Act is finally ratified, what's to stop a $5 billion credit fund or even a $1 billion credit fund from having a concerted marketing and advertising campaign over several years, basically pounding the table and saying, they're the best credit fund in the country. And what's to stop them from kind of stealing our territory? So they said to me, can you develop a campaign that will protect against attrition and protect against people trying to kind of steal our space and also ultimately stealing our clients? So there's no question funds are cognizant, and I think the more established funds, it's funny, the world I think is fractured. The largest of the large, the BlackRocks, Blackstones, Apollos, those guys have had vehicles, some of them are public, etc. They are ready to go. I mean, I was reading the New York Times on my iPhone the other day, and I'm sure as a lot of people did, I got a mobile ad from BlackRock. Now they're a broker-dealer, right? But a lot of people think that they just are doing this broker-dealer thing to advertise their funds. So I think what you see is the largest of the large funds are going to go after this aggressively. They know how to do it. They have vehicles that have done it successfully in the past. And then you're going to see basically the middle class, so to speak, the billion-dollar funds get into this, that want to kind of, get larger, that want to get into the $5 and $10 billion category, and kind of take over the world on their own.
Yeah, I guess one point to be made there is, and the ICI made it very clear in their comment letter, was that the advertising rules for mutual funds have developed over a long period of time. They're very specific rules, particularly with respect to performance. Rule 482 is very intricate. And the ICI was very concerned that in the private funds area, there's no standardization of performance returns. And so, Flavio, would you think that this would then, when the Jobs Act rules are finalized, do you think that this would then create standardization of returns? Do you think your underlying fund managers would have to meet a certain standard?
I believe so. I mean, one of the problems that we see in the industry, especially is within the indices, is the survivorship bias. I mean, basically, funds that tend to report as long as they're performing well. The moment that performance lags, you see funds just falling off the different databases. So I do believe that will be something that will be quite positive for the industry as a whole. I think also, as we see more integration between the alternative industry and, let's say, the more traditional industry through the 40 Act funds, I believe that that's going to be something where more and more alternative investment firms are going to feel more comfortable doing some type of work, and to some extent it's an area where we're looking at. We haven't really pulled the trigger on it, but we do believe that that's a potential area for growth in the industry that's going to be quite significant going forward.
That's a really good point, because there are now more and more alternative fund managers that are accessing further greater distribution through a registered type vehicle. Certainly we have clients that have done a 40 Act fund, or we have clients that are in a sub-advisor capacity in a fund-to-fund, registered fund-to-funds. And remember, when they advertise, they're mutual funds. They have to abide by all the 482s and 156s and 24Bs, all of that whole list of advertising rules. But hedge funds right now, without those specific rules, they really are just subject to the anti-fraud. Nathaniel, is there a way that funds can really trip themselves up if they don't have a whole set of advertising rules to be subject to? I think there definitely are. You can, for the one thing, being hedging, I don't want to say lying, but kind of hedging the truth on, hedging isn't the truth, isn't a good way to put it either. Maybe fudging the truth a little bit on performance. I mean, if you round up, just things like that, I think are very, can get kind of tricky. Calling yourself the best this or the best that. Very specific language. I think. I mean, I'm not a lawyer, but I would think that knowing a little tiny bit about hedge fund managers' egos and how they think of themselves, and maybe seeing that translated to paper, I would think that it might be kind of a little bit risky in some sense. So I think you're absolutely right. I think you need to have some kind of standards developed, like you do in the mutual fund industry, where you have to mention the benchmark and other things like that, because otherwise it could be very dangerous. If you have people out here like, I don't know if you guys remember a couple of years ago, this guy Christian Baja Super Fund. Do you remember him? Somehow he got around. He was on TV. He was an Austrian guy doing some kind of commodity strategy, and somehow he got around all of this. Or maybe he was just doing it fraudulently, or not fraudulently, but whatever. Aggressively.
Yes. He was on TV with all these TV ads talking about his what he might have even been pitching them as hedge funds, or definitely commodity CTAs, and that's just very, I think, pretty dangerous for the general population if you see something like that. And then when there is fraud, of course, it's going to all get blown up, and everyone's going to say, "There go the hedge funds again." So, it could be potentially pretty tricky.
Yeah, super fund is a really interesting. Actually, it's a commodities fund. It's a registered product on S1, so it's an operating company. It's not really a fund, and so because it's not technically a fund and therefore not a mutual fund, it's an S1 operating company. It's not subject to all of the fund advertising rules, and so they're really just subject to general anti-fraud in the same way that IBM would be subject to general anti-fraud. And so it took the Commission and the CFTC a while to get their heads around that one. But I think the point to be made from that is that there probably is a fair amount of opportunity to do creative things.
Oh, absolutely. Yeah.
And remember, just because there aren't specific rules with respect to advertising when it comes to private funds after the Jobs Act is completely implemented, they're not devoid of rules. So the advertising rule under the Advisors Act, 206, all the anti-fraud rules there, they still apply. And so one of the things now that people trip themselves up over, and I remember this back back in the 80s when San Francisco, when the 49ers were winning Super Bowls, Franklin Resources decided that they wanted Joe Montana to get out on TV and say, I throw touchdown passes and win Super Bowls, and I put my money in the Franklin funds. That's a testimonial, and it's illegal, and you can't do it. And so testimonials is one really simple way where funds will be able to trip themselves up, because you don't need any other rules for that. One of the other controversial areas in the Jobs Act proposal was whether the accreditation standard should be increased. And so in order to take advantage of this provision, every single one of your investors, if you're a 3C1 fund, has to be an accredited investor. And so, now if 3C1s, you can have up to 35 unaccredited. We always tell clients, don't do that. That's not a great idea. You can't charge them a performance fee. Plus, you're supposed to give them the information that would otherwise be found in a prospectus. Not a great idea. You can, but you shouldn't. But now you wouldn't, if you were to do this general advertising, everybody would have to be an accredited investor. Would it make sense, if we're going to have this rule, which we are, to raise the accredited investor standard, are we being too paternalistic there? Steve, should we think about that a bit?
I for one have always had a problem with the way that rule was put in place, because who's to say an economics professor that makes $70,000 a year but doesn't have $1 million outside of real estate isn't qualified to invest in a fund? I just find it, I find it strange and arbitrary and probably not the best way to go about it.
Nathaniel, did you have a view on that?
Well, I mean, how long has it been? What is it, $1 million? Or
it's $1 million. Real estate.
Yeah, and how long has it been that way?
Well, no, it was recently raised to $2 million.
Oh, okay. So, I mean, it makes sense that.
So Dodd-Frank raised both the accredited standard, and remember back 4 years ago when they wanted to do the qualified accredited person standard to raise it to $2.5 million. This is pre-Madoff, remember? Mm-hmm. The SEC got the most negative comment letters of any rule proposal they've ever put out. Like, I don't need Big Brother telling me what to do, all these kinds of, and so at that time, the public came out very much against further government oversight. Fast forward to Madoff, everybody was lining up saying, can the government give me my money back from Madoff? So a bit of an irony there.
I mean, if you have it, you're going to want to adjust it for inflation, I would think. It just makes sense. Whether government's in a position of, telling people what they can or can't invest in based on their income and levels of wealth or whatever is another topic for discussion, I guess. Yeah.
I want to open it up for questions. If we're a small group here, just stand up and shout out a question.
Can I just make a comment?
And Flavio, go ahead.
I think that from a fund manager standpoint, I think what's important here is to really make a decision on what kind of clients do you want to have in your vehicle, in your fund, and really try to control that by the size of the minimum investments that you allow clients to put in. So if you come in with a minimum allocation size of $1 million or $5 million, you kind of steer it away from, less sophisticated investors, I would say.
Has for you has the increase in the Jobs Act increased for 3C7 from effectively 500 investors before you become a public 34-Act reporting company to 2,000? Is that something that your group has thought about a little bit?
We thought about it, but at the end of the day, our largest vehicle is still the offshore vehicle, and really given the fact that most of our clients tend to be pension funds, I mean, that really solves the issue. I think that from that standpoint, we really have not felt it so much, and also ticket size tend to be a lot larger that way.
Steve, when you talk to clients, are they sort of poised to do are they concerned now that is this great news that I can have 2,000 investors in my 3C7 fund, or is that sort of irrelevant to a lot of these guys?
Assuming they're going to embrace the opportunity of the Jobs Act, they're excited about it because it helps initially overcome a hurdle, which is, if we embark on this advertising and marketing campaign, what do we do about the fact that we can only have 499 investors? Because I'm sure, if we do it well, then we can, go well above that. So they're excited. One thing you should mention is the commodity pool restriction.
Yeah. So so here again, here's a place where the regulators have sort of tripped up a bit. I guess 2 points to be made. First is that under the 40 Act, if you rely on 3C1 or 3C7, you're not permitted to publicly advertise or make a public offering, so that the rules have normalized that so that you can still rely on those exemptions if you also rely on 506C. So that one's taken care of. The one that's not taken care of, that Steve is referring to, is that if you are a registered CPO or CTA, and remember, a lot of people now, because of 413A4, which has been rescinded, many funds now, fund managers are going to have to register as CPOs or CTAs, and that has not been normalized, so the CFTC is not really on board. If you're a commodity pool, if you're running a commodity pool, it's right, as it is today, you would not be able to rely on the 506C, the Jobs Act provisions. So, that's, and I understand that there are discussions going on between the SEC and the CFTC to normalize this, but the CFTC has sort of dragged their feet a bit on this, the reason, not the least of which, is the Superfund.
Yeah, really.
So that that has come back to make the CFTC a little bit suspect of commodity pools being able to generally advertise. So, as it stands right now, if you are a commodity pool, you would not be able to generally advertise or generally solicit. Questions? Yes.
If we choose to generally solicit, are there different rules on how we judge whether someone is accredited? Are we going to have to do more work, or will we still rely on their self-representation?
Well, go ahead.
I'm aware of I've had a lot of people approach me. I'm aware of about 4 or 5 different technology providers that already have software in place that will do accredited investor validation. So even though this is the last piece, as far as I understand, between the two lobbies warring with each other, the ICI and the MFA, I very much get the sense that it's going to really be a non-issue, and this is something that's going to be taken care of electronically.
Yeah, the registered funds industry just went berserk when the SEC came out with their proposals, which had very loose standards. There was no, you need to get an income statement. There was none of that. Back in the old days, back in the 80s, when you had to do verifications, you had to get an income statement or a balance sheet. And a lot of people, like myself, thought that the SEC would go back to that old standard, but they didn't. They said, you should look at the nature of the offering. If you have to put in $2 million, then it's likely that they are. You have to look at the, the background information of the investor. Does this person work on Wall Street, or do they pick up garbage in Laramie, Wyoming? And so there were all these sort of amorphous standards, and the other side of the world really did not like that. I would suggest to you that when the rule gets reproposed, that is something that's going to get tightened.
But it does fall with the fund manager to do the verification.
Ultimately, it falls on the fund manager.
Yeah.
So if you take somebody, here's the rub, right? If you take somebody that isn't an accredited person, then you've just made a public offering, and you're an unregistered mutual fund. You've violated, God knows how many sections of the 33 Act, right?
But once again, there's technology providers that they have the software that they'll do the verification for you instantly. But the other question I have is, if somebody comes in from a broker-dealer, then from what I understand, you don't need to worry about accredited investor status.
Well, in your placement agency agreement, you would, with that broker, you would have a provision that says, we are relying upon you to do the accreditation standards, so, it's on you. And you indemnify us for that. So it's not automatic, but it's something that in your agreement with your brokers, you would have a provision in there that says you're responsible for these things. You rep to us that you have a way to do this that's reliable. We're relying on you. If you screw it up, you indemnify us.
I didn't know that. Is that pretty common?
Yeah, well, sure. In these placement agency agreements, third-party marketing agreements, the idea in those, and it's not just with respect to these kinds of things, it's pretty much everything. I'm responsible for what I do as a fund manager. The offering documents that I give you are correct. You can rely on them. And so if those offering documents are not correct, I indemnify you for that. And then you, broker, if you're out there telling people things about us, the fund management company, that isn't true, and there's an action against us because of that, you indemnify us because of your statement. You're responsible for your actions, we're responsible for ours, and we indemnify each other. Other questions? Yes, ma'am.
Are you seeing a difference in attitude from foreign fund managers who might have a business in the U.S. Versus U.S. managers in their approach to advertising or the Jobs Act in general?
Go ahead.
We've spoken to a number of European funds that have tried to get into the U.S. before but just can't get a foothold, and they really see this as an opportunity for them to finally crack the market.
Yeah, we see more fund managers setting up, non-U.S. fund managers setting up. Of course, after Dodd-Frank, there's certain ways that you have to do things now. You can rely on the old Unibanco letter, where you can have an advisor here and designate personnel that are part of that fund management organization, but you don't register the whole non-U.S. entity here. And that doing that would allow an organization then to take advantage of the Jobs Act provisions. One last question. Yes, sir.
Yeah, post 2008, it seems like the industry adjusted pretty well to fraud and came up with its own solutions, managed accounts, platforms, consultants. So I'm kind of interested in what your impression of the SEC's mandate is. Like, what are they trying to solve? Even with the Jobs Act, like, why are they going down this route? They think that they have some accountability to the broad public when it's a narrow public offering. And so then the follow-up question to that is, do you think that the longer term or broader direction is to actually take our industry, the alternatives industry, and make it available to everybody, kind of like a UCITS type thing in Europe, where first it starts out institutions want this, and then it's like so they can sell it to the general public.
Yeah, those are really great questions. First of all, you cannot underestimate what Madoff and Alan Stanford did to the morale of the SEC. They still call the Madoff, they still refer to it as the incident. Yeah. It just killed them. And remember, the SEC's mandate is investor protection. That's first. Orderly capital markets, ability to grow capital. So those are the mandates. That's a balancing act. Every time that the SEC provides greater latitude to the industry, they see themselves getting burned. And it's not just them. They do take investor protection fairly seriously. And now with what I mentioned before, the Dodd-Frank advisor registration standards being raised, you've got all the state administrators really very concerned. They don't have the resources to look at these smaller managers. And I don't know if you get the SEC and CFTC enforcement notice